Good afternoon, everyone, and thank you for joining today's webinar, which is on an update on discharge from Wardship. My name is Caoimhe Gleeson, and I manage the HSE National Office for Human Rights and Equality Policy, who've organised this webinar series from the Assisted Decision Making Capacity Act from legislation to practice. This is the second of our webinars, and we have a number of webinars that we'll be having a webinar each month for the next year. We have a number of presenters today. So we have Alice White from the Office of the Wards of Court, Eleanor Lean from the Legal Aid Board, Anya Flynn from the Decision Support Service, Joanne Condon from the National Advocacy Service for People with Disabilities. And then we will have a video with PJ Hurley, who's somebody who has exited Wardship, and then Michelle Angland, who's an ADM lead in St. John of God Services in Kerry. Thank you to all of you who sent questions in advance. Also, the question and answer function is open. You can ask questions when the webinar is in progress. We have people here who will be able to reply to you and address some of the questions live in the Q&A. Where we can address them online, we will do so as well. Please note that the webinar is going to be recorded. If there's any issues with apologies. As there's issues with the our section of the HSE website at the moment, we will send you the link directly after the event. Unfortunately, we weren't able to get sign language interpretation for the live event. However, we will get the recording interpreted before we share it. There's also a new report on that the National Disability Authority have just published some research on people exiting Wardship, and we will share the link of that research during the webinar as well. If you wish to have to get a certificate of attendance for your CPD, a link to a survey will be shared with you during the webinar for you to complete, and you'll need to send that to us immediately afterwards so that we can send on a certificate. So I'll make an announcement after each speaker about the link. Make sure you click on that link if you want a certificate of attendance. So without further ado, I would like to hand over to Alice White, who's the Registrar from the Office of the Wards of Court, who's going to talk us through the process of discharge of wards of court, the role of the medical visitors, and how progress has been in relation to this issue to date. So over to you, Alice. Thank you.
Thank you, Caoimhe. So good afternoon, everybody. My name is Alice White. I'm the Registrar of Wards of Court, and I will take you through what we've been doing so far in the office in relation to discharge from wardship. As you're all aware, the Assisted Decision Making Capacity Act commenced on the 26th of April 2023, and it requires that all adult wards of court be discharged by the 26th of April 2026. This will involve each ward of court being assessed and discharged under one of the 3 tiers of support available. Applications for discharge are dealt with under Part 6 of the Act, and specifically Section 55. All documents referred to in this presentation can be found on a link there. These slides will be shared afterwards, so you'll be able to click on the link and it will bring you through to all of the documents associated with a discharge application, and they are on the Court Service website. As some of you will likely be aware, there is amending legislation that has been approved by Cabinet and is making its way through the Houses of the Oireachtas at the moment, and this is to extend that 26th of April 2026 deadline. So we in the office are waiting for this legislation to pass now at this stage to extend that deadline by a period of 18 months, where the court certifies that there is good reason to an extension being granted. So assisted decision making has replaced substituted decision making in Ireland. Every adult ward of court is to be discharged. The relevant person will be assessed and will be aligned with one of 3 tiers of support or requiring no support. So the person may be discharged with no formal support arrangement or with the assistance of a decision-making assistant. They may be discharged with the assistance of a co-decision maker which involves making decisions jointly, where the relevant person will be supported by a co-decision maker to make decisions jointly. Or the highest tier of support is a person who will be discharged, requiring a decision-making representative. At all times, consideration must be given throughout the application process to the guiding principles of the Act, and these are contained in Section 8 of the Act. So the guiding principles assume there is capacity, that the person has capacity. It requires that all practical steps are taken to assist the person making a decision prior to an intervention. It also sets out that an unwise decision does not indicate a lack of capacity. If I want to go out and spend €1,000 on a pair of shoes, I'm free to do that. It might be viewed as being unwise, but it doesn't mean that I will have my capacity questioned. So, as I said, an unwise decision doesn't indicate a lack of capacity. An intervention only should apply when it's absolutely necessary, and the intervention shall not minimize any restriction on the relevant person's rights and freedom of action. It shall have due regard to the relevant person's dignity, bodily integrity, privacy, and their control over their property and affairs. And that in itself is to ensure that the right tier of support and the right tier of decision making is assigned to the person. Any intervention should be proportionate. Is there an urgency around it? You need to look at the significance, and it should be limited for the duration of which the intervention is necessary. The intervener shall permit and encourage and facilitate the relevant person's participation in the intervention. And this can be seen, and I'll address this later, under Section 139 of the Act. It must consider factors that the relevant person might have considered. They may consider the views of a person named by the relevant person, the views of a decision supporter who has been appointed. They may consider the views of a person providing care to the relevant person, and any person who has an interest in the ongoing welfare of the relevant person. They must act in good faith and for the benefit of the relevant person. Look at whether the relevant person is likely to recover. So is this a temporary period of incapacity? And they must look at what data and information requirements are in place. So just moving on to the actual application, the Wards Court Office currently has 2 application processes in relation to discharge from wardship. One being the traditional application process, which has been in place since the Act commenced. And the second is the review process that was put in place due to a statutory requirement on the office to list every matter that that an application was outstanding in prior to the 26th of October 2025. So in terms of the application, who applies? So for the traditional application, it was the committee of the ward of court, or on consent of the court, another person who is in a position of trust or has an interest in the welfare and the well-being of the relevant person. Those applications are on consent of the court, so it would have involved a court application, a judge granting that application and allowing somebody other than the committee or the ward to bring the discharge application. Now, as I've mentioned, we had to list all outstanding matters without an application by the 26th of October 2025. This involved the office submitting an application for a legal aid certificate on behalf of those wards of court and selecting or allowing the ward and their committee to select a solicitor from the panel arranged by the Legal Aid Board. So everyone has legal representation. Everyone has an application that has commenced, either through the listing of matters before the court under the review procedure or by a solicitor lodging an application in the office. So following on from that, then the next step is that a functional capacity assessment would be carried out. And this slide here is referring to the matters that were listed for directions before the court ahead of that deadline on the 25th of October 2025. The office, as I mentioned, appointed a solicitor under the legal aid scheme to deal with the discharge application. The office arranged for the functional capacity assessment report, and the office arranged for copy documents to be sent to solicitors. So the functional capacity assessment is carried out by one of the court's medical visitors. They will make contact with the committee, with the ward, or with a service provider to arrange for the capacity assessment to be carried out. And this will look at the relevant person's capacity to make decisions around the areas of welfare, to include healthcare, and property and affairs. So that would look at financial decisions. And it looks at the person's ability to understand the information relevant to the decision, their ability to retain that information long enough to make the decision, to use and weigh up that information as part of a decision-making process. So are they able to understand the pros and cons about that particular decision being made? And their ability to communicate that decision once it's made. And communication isn't just spoken. Communication is by talking, of course, but also writing, the use of Irish Sign Language, assistive technology, or even to communicate by means of a third party. And what we have found with our medical visitor reports are that parents are often very clued into how their adult child communicates with them and are able to interpret expressions and partial words and what they would mean. So the report, when it's completed, will recommend a tier of support to the court, and the judge will then make the decision based upon the recommended tier. So I've covered the functional capacity assessment. The office will arrange that, and we will provide a copy of the report to the committee, to the ward of court, and to the solicitor dealing with the application. The office will also prepare a statement of assets and income as known to the office, and we will provide that. So that would be a note of any funds that are lodged in court, any property, a car, a mobile home that might be owned by the relevant person. We will send this information along with copies of any prior orders that are relevant to the application, such as the declaration order, a court order appointing a new committee where there might have been a change of committee over the years, and the office will copy and provide this information for the solicitor. It is also open to the applicant, that would be the ward of court or the committee, to obtain their own functional capacity assessment. And they might want to do this for independence reasons, so they have their own report to rely on, or they might disagree with the recommended tier from the court's medical visitor. So it is open, and the judge will consider both of those reports and may even go as far as to hear oral evidence in relation to the relevant person's capacity. So some applications will also require a proposal on the future management of somebody's funds. Now, this isn't for every application. It's where the person is under a certain age, so 78 for women or 73 for men. And if they have more than 250,000 lodged in court, then a proposal is required as to how those funds will be managed And this does not need to be a detailed prospectus. A brief overview for the court is all that is required. Where a recommendation is made that a decision-making representative is required, the court seeks confirmation that the person proposed to act is suitable and is willing to act and isn't disqualified by any of the criteria as set out in sections 38 and 39. Now, as I've mentioned, every application will have a functional capacity assessment accompanying it. It will have a schedule of assets accompanying it, a medical report of the applicant. If a co-decision maker is recommended, then a proposal on funds, if it's required, is also submitted. Where a decision-making representative is the recommended tier of support, again, a proposal on funds may be required, and the statement confirming the eligibility of the decision-making representative is also required. So I mentioned section 139 earlier, and this is important because it looks at the involvement of the relevant person in the application process. So they are required to attend court unless it can be shown that they didn't want to attend the discharge hearing or a court application under ADMCA, or that it would cause their health to suffer by attending. The majority of wards of court do currently attend discharge hearings. They either attend online as the list is heard in a hybrid format, and some also attend in person. So it is important that the person is supported to attend the discharge hearing, that they're encouraged to attend the discharge hearing, and the solicitor will set out on affidavit to the court the steps that they took to encourage that participation and attendance. And if the relevant person opts not to attend, that must be averred to in an affidavit also. There's a requirement that any of the court hearings under the Assisted Decision Making Capacity Act are heard with the least formality possible. So we've mentioned will and preference previously. The applicant is required to inquire as to the will and preference of the relevant person. So that would be the solicitor will inquire with the relevant person at the point of serving them with documents and will record what their will and preference is. And this could be about a wide range of areas. But what we commonly see is the person's will and preference will be set out about who they would like to support them making decisions in their future. It might be around support arrangements or care arrangements that are in place, or accommodation. And a lot of our adult wards have expressed concern that the discharge application might impact their accommodation, and that it seems to be a theme, and we do seek to reassure them that the discharge from wardship, that change in status, will not impact their living arrangements or their current accommodation. The views of anybody as set out in section 8.8 of the Act, so a carer, a healthcare professional, a person with a bona fide interest, and you will be hearing from the National Advocacy Service later on this also. The will and preference, as I've mentioned, it's canvassed by the solicitor. It is recorded in an affidavit, and that information then is put to the court in the format of an affidavit. The decision-making representative order. So this is the highest tier of support. The court, it is the only tier of support where the court will appoint a decision supporter, and the court order then acts as the agreement. So the court, in making its order, which acts as the agreement, can confer powers on the DMR, can impose duties on the DMR, can attach conditions to certain decisions to be made, and it can limit the time and scope of the order. Also, more than one DMR can be appointed. So you can have a DMR appointed for welfare reasons, but you might have a separate DMR appointed for property and affairs. It might be that a panel DMR is appointed for one area and a family member decides to act for the other. When the order is drafted and signed, the Wards of Court Office send that order on to the Decision Support Service to be registered. And then the order and the agreement are reviewed in the Circuit Court no later than 12 months or up to a 3-year period if the court is satisfied that there will be no change in capacity during that 3-year period. A decision-making representative may also be appointed, is appointed where a person doesn't have capacity, even with the assistance of a co-decision maker, or they may be found to have capacity with a co-decision maker, but there is no person available or willing to act. So in that point, in the absence of having a co-decision maker, the court will appoint a decision-making representative, and that would be from the panel managed by the Decision Support Service. A panel DMR may also be requested if the co-decision making agreement is not registered within 5 weeks of it being signed. It is taking a number of months for those agreements to be registered. A person is not available to act as a co-decision maker for the relevant person, and the decision-making representative, the panel DMR, is requested on a request through the Wards of Court Office to the Decision Support Service. 2 nominees are put forward to the court, and the court selects one of those nominees to act as the DMR. So just in terms of following on from the court hearing, the office arranges for the return of assets to the relevant person. Now, to do this, the court order is signed and that's sent out, and either the relevant person or the decision-making representative will arrange for a bank account to be opened, and those details are sent into the office. On receipt of those details, the Wards of Court Office will arrange for the payment out of funds that are held in court to the bank account details provided. Now, this takes a minimum of 3 to 4 weeks to be processed in the office. So that would be from receipt of those bank account details. To ensure that people have sufficient funds available, we are front-loading funds either to a service provider, a committee, or to the Ward of Court to ensure that they have sufficient funds available for their care needs and their living requirements for that period of time. So practical considerations to be thought about in advance of the discharge hearing. Does the relevant person have a bank account? Are there appropriate financial safeguards in place? Is the relevant person in the middle of litigation or a probate application? So do they have ongoing court proceedings for one reason or another? Are there current welfare needs? When the solicitor is serving the relevant person with the application for discharge and with the functional capacity report, the relevant person may require support for the purpose of that service. Is the relevant person subject to a deprivation or prevention of liberty safeguarding order? So is the relevant person subject to an order placing them with a service provider or providing for ongoing medical care and treatment? If so, a structure needs to be put in place to allow those orders to continue, and this is managed through the inherent jurisdiction list in the High Court. You may want this is more for the solicitor, but also for service providers. They can make contact with the office if they have concerns about somebody who has been proposed as a decision support person to the relevant person. And the court will always take on board any concerns raised by service provider. Is there interagency involvement? So we may have some wards, adult wards who are exiting wardship who are supported by the Child and Family Agency, but also by the Health Service Executive. So just in terms of administration and stats then, we have discharged 325 wards of court to date, and we have 1,470 adult wards of court going through the discharge process. The email address for the office, if anybody has queries, it's wards@courts.ie. And as I've mentioned, all of the documents referred to in the presentation are available on that link, and these slides will be emailed out afterwards. So just a couple of further matters. The funds cannot be retained in court. When a person is discharged from wardship, one of the directions in the court order is that their property and assets are returned to the relevant person. Reports coming in from medical visitors do need to explain why the medical visitor arrived at a particular recommended tier of support. So it's not just enough that the medical visitor will say what the required tier is. They need to show the court how they arrived at that particular recommendation. Previous reports are available from the Wards of Court office for any medical visitors who might feel that these are beneficial. Also, something to be considered as part of the application is the ability of the person to make decisions around medication and healthcare. And again, that's something that falls into consideration under the welfare heading. And that's the end of my presentation. Thank you, and passing back now to Caoimhe.
Thanks very much, Alice, for a really comprehensive overview. Just a few things to confirm that the slides for all of the presentations will be made available afterwards. I know there was a couple of questions in relation to some of the specifics of Alice's presentation. And secondly, just to note that the link for CPD has been shared. You should be able to see it in the questions and answers function. We'll pop it in again as well. So just if you are looking for CPD, you need to fill out a survey so that we can send that information to you as well. So I'm going to move on now to our next speaker. Just give me a moment here. So our next speaker then is going to be Eleanor Lean, who is from the Legal Aid Service. So Tom, I just see that Alice is her screen is still in the middle, so I don't know if that's changing for other people. So Eleanor is going to talk about specifically about the element of legal aid and support for a person who's being discharged from wardship. So over to you, Eleanor. Thanks so much.
Thanks, Caoimhe. Okay, so today I'm going to talk about discharge from wardship, legal aid, and the role of the legal aid board solicitor. So first of all, just in relation to legal aid and qualifying for legal aid. So normally a financial eligibility test applies to applicants for legal advice and legal aid representation. The Assisted Decision-Making Capacity Act 2015 amended the Civil Legal Aid Act 1995 on the financial eligibility rules for applications for legal aid for discharge from wardship proceedings. So no financial eligibility test applies where the applicant for legal aid is the ward of court. So then the normal financial eligibility test applies to any other person who's applying for legal aid for discharge from wardship. So what does that mean? A ward of court qualifies for legal aid regardless of their disposable income and regardless of their disposable capital. A ward of court is not financially assessed to establish if they're eligible for legal aid, and no advice or aid contribution is payable by a ward or a committee applying for legal aid on behalf of the ward in discharge from wardship proceedings, as would be payable in any other legal aid matters. Just to briefly mention clawback of costs then, the 2015 Act provides for recovery of costs from a legally aided ward who would not have satisfied the financial financial eligibility test that's normally used. The 2015 Act also provides that the lab may recover some or all of the costs of providing legal aid where the ward would not have satisfied the test. However, the 2015 Act actually provides that the mechanism or the rules for recovery of costs would be provided for by way of further regulations. No regulations have been made on cost recovery to date. The Legal Aid Board has engaged with the Department and the Office of Parliamentary Counsel in relation to what those regulations might look like. But at this stage, the recovery of costs and those regulations will not affect the wards of court to whom legal aid certs have already issued. So there would be no cost implications there for those cases. So then legal aid for the non-ward applicant, just to mention that because you may have families and other people involved with the ward who may be looking for legal aid. So any other person seeking legal aid for discharge from wardship proceedings must be financially assessed, must be financially eligible for legal services, must pay the legal aid contribution assessed on their disposable income and their disposable capital. But in their case, there's no liability for the actual cost of the proceedings above what they pay by way of the legal aid contribution. So just to talk briefly about applications for legal aid. So the Legal Aid Board processed applications for legal aid for wards of court from wards of court personally, from wards of court personally where they were assisted by service providers and advocates. We accepted applications from the committee of the ward of court applying on behalf of the ward of court. And as Alice mentioned, we also accepted applications from the wards of court office following an order of the President in mid-2025, which allowed for applications for legal aid for wards of court to be submitted by the registrar. Then just some statistics on the Part 6 legal aid certificates. In total, 1,842 Part 6 legal aid certificates have been granted. You can see that there was obviously a very slow uptake in 2023 while people were, I suppose, trying to see what the process was going to look like. It increased in 2024 to 214, but by far in 2025 was the highest amount of legal aid certificates granted, both by committees applying for legal aid, I suppose, once the cost recovery aspect of things had been confirmed, and then also by virtue of the applications from the wards of court office. So I'm now going to talk about the role of the legal aid solicitor in the discharge process. And a lot of what I say will cross over with Alice, but it's just important to go through what our role is in the process. So the steps involved in the discharge from wardship are set out in Practice Direction High Court 133, and this replaced an earlier practice direction in June 2025. On assignment of legal aid, an initial application for discharge from wardship is filed with the wards of court office by the solicitor assigned to the case, or following the directions hearing that Alice mentioned earlier. This starts the process for discharge and triggers the attendance of the medical visitor with the ward of court to carry out a functional capacity assessment. The wards of court office will also advise the solicitor if a financial plan will be required by the court with proposals for the management of the ward's funds held in court, which will be released on the discharge from wardship. This is so that they can start taking steps in that regard, so that there's no delay in getting the matter across the line when the other proofs are in order. So the functional capacity assessment, as Alice outlined, this considers the person's capacity in relation to property and affairs and personal welfare decisions. The medical visitor may look at discrete areas and make comment or offer opinions. On completion of the functional capacity assessment, it's returned to the court office, who in turn provide it to the solicitor for the ward, along with a statement of assets, a copy of the declaration order that took the ward into wardship initially, and any other relevant orders or documentation held on the ward of court file. The functional capacity assessment and the findings in that assessment are the basis for the legal papers for discharge from wardship that are prepared by the solicitor. So there is a grounding affidavit and a form known as the WOC2 form, which are the main forms that are completed by the solicitor. The solicitor prepares the grounding affidavit and the other papers. And then the next step, and the important step, is the service of papers on the relevant person. So the grounding affidavit, the exhibits and the medical visitor report are served on the ward of court twice. So initially following the preparation of the court papers, post the medical visitor report, and again when the court hearing date is fixed. So I'm just going to talk a bit about what happens when those papers are served. So it's important that all of the service and the discussions during that are in plain English. So everything is explained in plain English using appropriate aids as necessary, or with the assistance of advocates where involved in supporting the ward. Other things like interpreters might be required, sign language interpreters, and the other aids that Alice mentioned, and of course family support where that is required also. Rapport building, so the solicitor introduces themselves, tries to get some background from the ward, asks them about their family interests so that they can build up a rapport with them so that they can then proceed to discuss the legal issues. So the solicitor then proceeds to explain why they're there, that the court is hearing about their case and making a decision on whether they need support to make decisions. So just to then look at the functional capacity assessment in particular, before visiting the ward of court, the solicitor will review the functional capacity assessment to ensure it's completed in accordance with the assessment of capacity provided for in Section 3 of the Assisted Decision Making Act. At the meeting with the ward, the solicitor explains the findings of the medical visitor in the functional capacity assessment, outlines in plain language the possible tiers of support, and then what the tier of support recommended by the medical visitor will mean for them and the implications of that. The solicitor explains that the ward can obtain a further functional capacity assessment if they disagree with the findings of the medical visitor. And where this arises, the solicitor will explore that further with the ward. And it's just important to state here that the Legal Aid Board will, on application, cover the additional assessment, the cost of that for a legally aided ward, where the findings of the medical visitor are not accepted or where an independent report is required. So the solicitor will canvass the ward's will and preferences around who they would like to be their decision supporter, where the decision support by way of co-decision maker or decision-making representation is recommended by the medical visitor. The solicitor must be live to any previous or current familial issues, must look out for any conflicts or potential conflicts, be alert to any safeguarding concerns while canvassing the will and preferences of the ward. The solicitor must record any reaction, views, or anything expressed by the ward as part of recording will and preferences. All of these discussions and everything that is talked through with the ward must be recorded in an affidavit of service, which is filed with the court papers in the court office. It's important to note that the solicitor can also speak to service providers, advocates, hospital or nursing home staff, healthcare providers, or any person involved in caring for and supporting the ward to canvass their views or concerns and to gather further information. So this is provided for under Section 8.8 of the Act in the guiding principles. So the affidavit of service of the papers on the ward is prepared and this is filed in the court office, and this then triggers the fixing of a date for the hearing of the discharge application. Following this, there is a second service of the papers on the ward with the hearing date. During that second service, the ward will be advised about the court date and encouraged to participate in the process, and we will look at options and supports that are required for that attendance. The solicitor will record the reaction of the ward to attendance at hearing and to the application in general again. The other thing that is canvassed at this stage is confirmation of the nominated decision supporter, where a decision supporter is the tier of support that's required. A booklet of papers is prepared for court, including the second affidavit of service. And the other important thing is that where a DMRO is being proposed, who's not a panel member, the solicitor will engage with the proposed decision-making representative in advance of hearing to ensure their understanding of the role and their suitability to actually take on the role. So Alice went through the voice of the relevant person, and I think it's just important to highlight it again from the perspective of the solicitor. So for the hearing of the discharge application, the papers will be open to the court by the solicitor or the barrister, but the discharge application is to be heard in the presence of the relevant person unless it would not cause an injustice to the relevant person not to be present, or where attendance at the court may have an adverse effect on the health of the relevant person, or where the relevant person is unable by reason of old age, infirmity, or other good and substantial reason not able to attend the hearing. The relevant person may be unwilling to attend. So the essential steps there on the part of the solicitor in those circumstances are to canvass and encourage the attendance of the relevant person at the court hearing, to consider the effect of attendance at the hearing on the relevant person's health and obtain the views of service providers or treating clinicians on attendance, to consider and engage with the court office on any supports that might be required to facilitate the attendance. Where the relevant person cannot attend or is unwilling to attend, the solicitor must outline the efforts to encourage and arrange for participation to the court. Where it's not possible to elicit current will and preferences, the solicitor must outline the efforts that they made to establish these, and the solicitor may consider past will and preferences and may canvass the views of others, as I've outlined, including service providers or clinicians, and may review and exhibit any relevant reports. So post-hearing, so the role of the Legal Aid Board doesn't stop at the point where the discharge is made. So the solicitor must advise on the outcome of the hearing and take any necessary steps to ensure that all necessary elements of the order on discharge are complied with. This may involve the continued involvement of the legal aid solicitor for the registration of a co-decision-making agreement. So where the court makes a declaration that the ward lacks capacity, unless the assistance of a suitable person as a co-decision maker is made available to him or her to make one or more decisions, the solicitor acting for the ward continues to provide legal services to the ward in respect of the application to register the co-decision-making agreement with the decision support service. Generally, and just to talk about legal aid for the co-decision-making agreement, generally any applicant for legal advice to register a co-decision-making agreement must be financially assessed, must be financially eligible and pay an advice contribution. However, where legal aid cert was granted to the ward for the Part 6 discharge proceedings, a new application for legal services for registering the co-decision-making agreement is not required from the ward. A financial assessment is not required, an advice contribution is not required. The services are provided as an ongoing element of the Part 6 discharge process. So the solicitor involved will contact the legal aid board head office, and the service will be added on to the original Part 6 legal aid certificate. So then just to mention the reviews in the Circuit Court post-discharge, which Alice mentioned. So the Act provides for a scheduled review of declaration within 12 months or up to 3 years in certain circumstances. And then there is also provision for review at any time on application of the relevant person or other persons with consent of the court. An application for legal services may be made to the Legal Aid Board for legal representation for the relevant person for either type of review by the Circuit Court. Examples of these types of cases might be where the decision-making representation order made on discharge needs to be reviewed, where it is too wide-ranging or not specific enough, and to ensure that the decision-making representative can take all the appropriate actions that they need to take on foot of the order. Lab representation is not required in all reviews unless there's some change of circumstances, like a change in capacity, an issue in relation to the DMO appointed, or a change or extension to the terms of the original order, which require the relevant person to receive independent legal representation again. So just to talk then on legal aid for that aspect of things, the Assisted Decision-Making Act further amended the Civil Legal Aid Act in relation to financial eligibility for those proceedings under Part 5, and reviews will fall under Part 5. The relevant person is therefore entitled to legal aid again without reference to financial eligibility. They won't be assessed for financial eligibility. They do not need to be financially eligible, and they do not need to pay an advice or aid contribution for the review process. The Act does again provide for recovery of costs in the case of a relevant person who would not have been financially eligible. But again, in the absence of regulations on cost recovery, clinicians and healthcare staff may assist patients, service users or families. So it's important that you inform yourself about the processes and the guidance available, which obviously you are doing by attending today, that you assist the patient service users, post them and their families to the Legal Aid Board and the other organisations for information and services, that you assist and engage with the solicitor on the 2 meetings with the relevant person and provide support and prepare the relevant person in advance for those meetings, that you advise the solicitor of any important information, conflicts, concerns which the solicitor may not be aware of, and provide views as per the Section 8.8 guiding principles. That you advise of requirements and assist the solicitor in putting in place any supports to encourage elicitation of will and preferences and to facilitate attendance at court, and that you facilitate the relevant person joining proceedings remotely where they cannot attend in person. So this slide here just has some links to lab resources. There's some leaflets and videos that have been prepared recently. We ran a campaign at Christmas, and there's videos there that are available on the role of the Legal Aid Board and the various aspects of the Act. So that is all from me. So thank you, and I can deal with any questions at the end, and I'll hand you back to Caoimhe now.
Thank you, Eleanor. There was a lot of detail there. Just to let people know, it was just slightly glitchy, just in case you think it's at your end. It was a little bit glitchy towards the end there, Eleanor, but I think we captured most of it and we're able to see the slides anyway. So thank you for that. Super. We're going to move on. So just to say, for those that joined late, there is a requirement for you to fill out a survey if you're seeking CPD points. That information is in the Q&A function, or just ask the question again and we'll post the link into the Q&A function. We're going to move on now to Anya Flynn, who is the Director of the Decision Support Service, who's going to tell us about what happens when a person leaves and what's the role of the Decision Support Service in relation to supporting people who are discharged and may need one of the requirements, one of the supports under the Assisted Decision Making Capacity Act. So over to you now, Anya. Thanks so much.
So the role of the DSS, thanks very much, first of all, to the HSE for the opportunity to contribute to this webinar and to set out to ensure understanding as to the role of the DSS when it comes to Part 6, because it is a limited role. So that the Decision Support Service has no role in the management of Part 6 applications. You've been hearing about that in detail from Alice in the Office of the Wards of Court. We're not a notice party to Part 6 applications, which means we don't become aware of them necessarily. And the engagement with the DSS's statutory functions arises in just a couple of ways. So that, when requested by the Wardship Court, the DSS nominates DMRs from its panel of DMRs for possible appointment by the court. As an outcome, we register decision-making representation orders made by the Wardship Court, and we're responsible also for the review and registration of co-decision-making agreements, or CDMAs, when these are the outcome of the discharge process. And I know that I've noticed a few questions in the Q&A about how CDMAs come about, and actually also about panel DMRs, including how they are remunerated. So I will be addressing that. Then following the discharge of a ward of court under Part 6, so in the post-wardship scenario, the DSS supervises compliance by co-decision makers and DMRs where these have been appointed. We have, of course, a general statutory duty to promote confidence and understanding in relation to all aspects of the 2015 Act, and that will include Part 6. So we've contributed to a number of events similar to today's. We have resources available on our website about what the Act means for exiting wards of court, and often point to the resources that have been developed by others. So requests for nominations from the DSS panel of DMRs. So where there isn't a suitable willing DMR, the court shall seek nominations from the DSS panel. So we have, under the Act, established a panel of persons who are suitable and willing to act as DMRs, and more in a moment about who those DMRs are. This panel member request is communicated to the DSS by the court. Alice has alluded to that already. And then the DSS provides nominations, usually 2 names. And a process has been agreed with the court service for panel member requests. This arises also, in fact, more often with the Part 5 applications that come before the Circuit Court. We operate our panel in strict rotation unless that panel member request discloses specific additional requirements. And just in terms of our relationship with the panel DMR, they aren't contracted to the DSS. A panel member is under no obligation to accept nomination by the DSS in any case. Also to note that at the time when the request for nominations comes in, the DSS holds no information about the case or the particular ward of court other than contained in the request and the accompanying court order, if that is provided. The DSS, as I've mentioned, isn't a party to these applications before the court, so we don't know the substance of what is before the court. We typically don't see the capacity assessment and aren't seeking to, so the information that we have is limited to what is provided to us by the court. And appointment by the court in every case is something which only the court can discharge. Or again, if a DMR has been appointed, they can't exit the case other than by way of a further application to court. Panel recruitment. We have conducted already 2 recruitment campaigns for admission to the DSS panel, and the third, as I speak now, February 2026, is ongoing. In addition to what is necessary to be a DMR at all under the Act, because there are limitations about who might be ineligible to do with criminal convictions or past barring orders or safety orders, for example, but when it comes to panel membership, the DSS requires that this is somebody who is registered in Ireland with a professional regulatory body, and that registration is as a matter of law. There are standards around educational attainment and proof of professional indemnity insurance to cover the activities of a DMR. And then we also assess competency as per a framework which has been devised for this purpose. We have interviewed all DMRs who are on the DSS's panel. That's a competency-based interview. And as you might expect, this is subject to Garda vetting, reference checks, proof of qualifications, proof of professional registration and completion of a training programme. The DMR panel member completes a declaration when appointed, and then they're required annually to establish that their credentials remain in place. This is true as of last month. So it's something which will be shifting as we complete the next phase of recruitment. So this is really just for information. This slide obviously will be distributed. Just looking at the information to the right of the screen, and as of January 2026, a total of 1,905 decision-making representation orders had been sent to us by the courts, both Circuit Court and Wardship Court. And as I mentioned, there are 22% of all registered decision-making representation orders included a panel DMR. So that's all, both Part 5 Circuit Court and Part 6 Discharge from Wardship. The experience at that point had been that 68% of all DMROs, orders coming from the Wardship Court, had looked for a panel DMR. That might change. As a discharge goes forward, there would probably to date be a significant representation of wards who had the general solicitor as their committee, and perhaps it was to be expected that wards within that cohort were more likely than others to end up with a panel DMR. As of January last month, panel DMRs had been appointed to 323 then active decision-making representation orders. There was a question in the Q&A about how panel DMRs are remunerated, and they're entitled to payment for their role and may be paid out of the assets of the relevant person, where those assets are sufficient for that purpose, or by the DSS according to a scheme of fees, and that is set by regulation. The court decides who pays the panel DMR. All payment is subject to certain annual limits set out in regulations and subject to pre-approval by the DSS. So in broad terms, under that regulation, the annual payment per panel DMR per relevant person or former ward is in the order of €5,000, but the panel DMR may seek excess remuneration in exceptional circumstances due to the complexity of the case, or if they can establish to our satisfaction that additional work was required. We thought this might be helpful, so we have devised an information leaflet on the role of the panel DMR for the better understanding of family members whose loved ones have been appointed a panel member DMR. And this is to set out the role of the panel DMR in those cases. And the information might be of use also to services. I think to understand that if somebody is a social worker, is a solicitor, they haven't been appointed as the former ward's social worker or solicitor. They bring a certain professional expertise to it, but they are fundamentally the decision maker stepping into the shoes of the former ward. They haven't been appointed to dispense professional services to them. Co-decision making, there were questions about this also, and as you've heard, this could be the outcome of the Part 6 review. Ellie has quoted already this section of the Act, which says that the Wardship Court may declare that the ward lacks capacity unless assisted by a co-decision maker, and this has been the declaration in a minority of cases to date. If that happens, the ward and any proposed co-decision maker are then referred to us, to the DSS, and as you've also been hearing from Eleanor, the legal aid certificate extends to support the registration of the co-decision making agreement, and that's very important that there is that handover and continuity of support. The DSS has assigned a point of contact to manage these sorts of co-decision making agreements coming to us in these circumstances. Alice has mentioned a timeline of around 6 to 7 months to get these CDMAs registered. For clarity, it doesn't take us 6 or 7 months to register a completed co-decision making agreement, which is compliant with the Act. The lead time tends to be around the creation of the co-decision making agreement. If one considers that these are parties, the former ward and their co-decision maker, who probably haven't given thought to what would go into a co-decision making agreement at this point, and need to think what needs to be included, and the DSS has no prior contact with these people. We don't know their circumstances. So we provide a level of support, but it's really important that the solicitor is on board to help with the registration, which when it's submitted to us doesn't take 6 or 7 months. It takes something in the order of 10 weeks currently, which includes a 5-week notice period set by the Act. And that might be helpful. That is a resource for legal practitioners helping with making a CDMA in all circumstances, which could include as an outcome of Part 6. Just important to say also that Part 4 applies in full in respect of CDMAs made in these circumstances. So there isn't anything in the Act which says because the Wardship Court, or indeed the Circuit Court under Part 5, says that a CDMA is the good outcome here. That doesn't write the co-decision making agreement. It doesn't abbreviate the processes under Part 4, which mean that a CDMA has to be created and sent to us for registration, and all of the requirements under Part 4 apply, including the inclusion of a capacity statement saying that the appointer, as the former ward is now called, has capacity to decide to enter into the co-decision making agreement, needs the assistance of the co-decision maker, and has capacity to make the decisions with the assistance of the co-decision maker. So that capacity statement is not fulfilled by the medical visitor's report or the declaration of the court. These three assertions need to be spelled out in a specific capacity statement for this purpose. The CDM is a relative or friend in a pre-existing relationship of trust. There isn't a panel of DSS co-decision makers, and I think perhaps important to consider whether Section 41.3 and 38.8a help us here, so that if somebody doesn't have a suitable co-decision maker, and if the registration of a co-decision making agreement apparently isn't happening, the court might appoint a panel DMR, but that panel DMR then is, under the Act, obliged insofar as practicable to make decisions jointly. And the court can, under 38A, 8A, say that a DMRO made in those sort of default circumstances would cease if in future a CDMA does come to be registered. Post all of this, we step up to supervise DMROs, first of all. The authority is based on the court order, not on registration by the DSS. There are restrictions which apply to any DMRs, that they can't make decisions about life-sustaining treatment, keeping another person away. There's no authorization for restraint or detention, and a DMR can't gift unless specifically authorized. All DMRs, panel or otherwise, submit reports to us. Within 3 months, they must submit a statement of assets, liabilities, income and expenditure if they're reporting on property and affairs, and thereafter annually. And we supply support in terms of template reports and guidance. But if reporting isn't being complied with, we may apply to court for the removal of that particular DMR. The review of the capacity declaration has been mentioned. So just to state, that isn't itself a review of the performance of the DMR. That's a review of the court's declaration made in relation to capacity. And as you've been hearing, that happens in the Circuit Court under Section 49. We are seeing that sometimes the opportunity is taken to adjust the decision-making representation order itself, and DMROs can always be brought back before the court for adjustment and variation. As I say, sometimes the opportunity is taken at the capacity review. We supervise CDMAs also under Section 26, which is unique to CDMAs. We carry out a review of how the CDMA is going and require an updated capacity assessment. So that happens, and these have been happening, within the 9th to 15th month after registration, and then every 3 years. And if we find that capacity isn't what it was, or for any other reason the co-decision making agreement is no longer fit for purpose, we can apply to the Circuit Court for a determination as to whether the CDMA should remain in place. And then, rather like the decision-making representative, in any case, the CDM is reporting to us, in this case, annually, setting out, as you see here, details of transactions that they've been involved in and any expenses that they may have claimed. A CDMA can never be remunerated. It's expenses only. Again, there are template reports. And if the reporting is incomplete, we try very hard to get it on track. But we may need to say that the CDMA is at an end, and that becomes appealable. Just to conclude, there are codes of practice, and there are codes for co-decision makers, codes for decision-making representatives, and they're available on our website with other materials and resources. And also, as a further safeguard, if things have gone quite badly wrong, complaints can be made to the DSS about CDMAs or decision-making representatives, DMRs, on specific grounds set out in the Act, including that they're acting outside of scope or in breach of the Act or are not suitable. And we have those powers to take up information and to refer to court for a determination as to whether the DMR or CDM should remain in place. But we try, again, to resolve those informally if that's possible at all. And there I will conclude. Thank you very much, and handing back to Caoimhe.
Thank you, Anya, again for a very detailed presentation, which again will be made available to all participants after the event. Um, and just to acknowledge as well, there's a significant amount of questions that have been answered by our panel members in the Q&A function. I just want to draw your attention again, just for those that missed it, if you are seeking CPD or cert of attendance, there's a link to a survey in the Q&A function. Please click on that in order to be able to get your cert of attendance. If you've missed it, just ask the question again. But if you look into the Q&A function, you'll see that. Thank you. So I'm going to move on now to Joanne Condon she's the head of the National Advocacy Service for People with Disabilities, who the advocates of whom have been supporting people to exit wardship, and have quite a lot of experience in this regard. So over to Joanne. Thank you.
Thanks very much, Caoimhe, and good afternoon, everybody. So I'm going to look at what's been happening in terms of our work as independent advocacy service with discharge from wardship. So for anyone who doesn't know what we do at the National Advocacy Service, very briefly, we're funded by the Citizens Information Board, who have a statutory remit to provide representative advocacy specifically for people with disabilities. It's a full professional, independent, free and confidential service with staff right across the country. And we have long-standing experience supporting people who are wards of court board, both pre and post commencement of the Assisted Decision Making Act. NAS has a particular remit then for adults who are over 18 with disabilities, who live in the community and are isolated, who have communication differences, are inappropriately accommodated, living in residential services or attending day services, and those with limited informal or natural supports. Helpfully, the codes that Anya has already mentioned, there is a code for independent advocates specifically that sets out a definition of independent advocacy as a professional support service provided by an organisation free from conflict of interest and independent of family and service providers. So the role of the independent advocate in ward of court discharges. Well, advocacy plays a really, really critical role in ensuring that people's voice is heard and that their rights and their autonomy are upheld. And since commencement of the Act, NAS advocates have supported people to receive information about their rights in the new Act in accessible formats, to be viewed as decision makers in their own rights, thereby upholding respect, dignity, and the person's autonomy. They've been supported to have their voice heard with independent impartial support where discharges from wardship are underway in line with the guiding principles of the Act. They've been supported to attend proceedings in person or remotely where they wish to do so, and advocates have supported people to seek reasonable accommodations where necessary. And finally, people have been supported to communicate with their legal representatives and to make their views directly known to the court regarding relevant matters. In terms of our practice then, advocacy is a very unique role. It's complementary to the other roles and people involved in proceedings. And importantly, it's entirely led by the person. It's a key principle of the United Nations Convention on the Rights of People with Disabilities that people who require support to exercise their autonomy should have access to it. And advocacy is a key part of that. Without that support, people can often not navigate the complex system, they can't obtain information in accessible formats, or have their voice heard and respected in decisions about their lives. In terms of accountability, all of our advocacy cases are reviewed and supervised by senior advocates and regional managers. NAS has a full suite of policies, a code of practice, and I've already mentioned full adherence to the DSS code for independent advocates. And all of our advocates have continuing professional development and training through our organisation's training plan. So importantly then, NAS has a specific remit, which I mentioned, to provide advocacy to people who communicate differently. And in such cases where perhaps somebody with maybe an intellectual disability may not be able to verbally share their will and preference where proceedings are taking place, the advocate can use 4 internationally recognised approaches to gather important information to inform the court in its decision making with regard to will and preference that may be observed by spending time with the person or speaking to those who know the person well, or indeed looking at their rights and ordinary life principles in terms of their day-to-day living. To give a flavour of our work in the area to date, so these stats are taken from commencement date of the Act through to yesterday. And of the 3,513 advocacy cases worked since then, almost a quarter of our work has been in the area of the Assisted Decision Making Act, and then specifically with regard to our engagement of people who are wards of court and indeed undergoing discharge. That would be 79. So I'm going to just give two quick examples of our work with people who were wards of court. The first is Enda. So Enda was living in a long-term residential setting following a brain injury, and Enda was made a ward of court on admission to the residential setting many years ago. Their social worker submitted a referral to us to ensure that Enda's will and preference would be heard through the discharge process. A capacity report that was organised by the Ward of Court Office recommended a decision-making representative be appointed for Enda for financial decisions. However, the NAS advocate explored this with Enda to see what supports he felt he needed and who he wished to receive support from. The advocate then helped Enda to communicate his views to the social worker, and another capacity assessment was submitted by the service's multidisciplinary team, indicating that a co-decision maker would actually be more appropriate for Enda. Both reports were submitted to the High Court, and the advocate supported Enda to express his will and preference to the court and attend the hearings remotely. The judge reviewed both reports presented and acknowledged the support of the NAS advocate in assisting Enda. The court outcome was that Enda should have a co-decision maker appointed, his niece, and Enda was in full agreement and happy with this outcome. The second example is Beth. So an advocate was already supporting Beth with a number of other advocacy issues when she voiced that she'd received a letter informing her she would be discharged from Wardship. She voiced apprehension as she was unsure of what this process involved and what it meant for her future. And as a result, Beth was supported by the NAS advocate to build her understanding of the Ward of Court discharge process. The advocate used the Decision Support Service's easy-to-read document available on their website that explained the process and what the person could expect during the meetings with their appointed solicitor and medical visitor. Important to note here is that the person hadn't previously been given those easy-to-read documents, although they were on that website and available. Beth was then supported to identify any questions that she wished to ask during the scheduled meetings to ensure that her voice was heard during the discharge process. Her advocate attended court with her on the day, and this culminated in a positive experience overall for Beth. A very specific DMRO was put in place, and she was happy with this. To give a general sense and flavour then of the experiences that we have noted in our work with people who have attended proceedings. So some people have chosen to join proceedings remotely with the support of their advocate. For others, they've chosen to attend in person, again with the support of their advocate in court. And then for others, they've chosen not to attend proceedings, but to make their views and wishes known to the court with the support of their advocate by writing what we call a will and preference letter to the judge and the court. And that would always be done in the way that the person themselves wishes to do so, in words that make sense to them. Judges have noted that these will and preference letters from the person have provided great insight into a person's thought processes and their specific wishes around who they would like to have support them to make decisions with other specific views. Experiences of court interactions with the person, of course, differ from case to case. Sometimes judges take time to ask the person about aspects of their will and preference set out in their letters, such as a wish not to have a family as their decision-making representative. And judges have broadly been very supportive of the person when they are involved in proceedings, welcoming them, explaining reasons for delays and discharges, asking them if they're happy with proceedings, and giving them an opportunity to ask any questions that they may have. Advocates' collective experience overall is that there has been less engagement, however, between judges and the person when compared to ADM hearings that we attend. A few considerations then emerging from our work in the area. The first thing is the importance that people and their supporters definitely remain anxious and uncertain about the ongoing changes. We hear that constantly. And there is a need, therefore, to build continually on the work already taken to promote an understanding of the Act and ongoing training for relevant professionals. Secondly, we would call for the need for a distinct panels for co-decision makers where people have limited supports. Obviously, coming out of Wardship can be a daunting process for people and their supporters. And even where people may be found that it's not necessary for them to have any formal decision-making arrangements and to be fully discharged from Wardship, it's our experience that sometimes people have never had the opportunity to exercise decision-making, and it can be too big a jump. And we have seen people, even where it's not recommended, choose themselves to put an assisted decision-making agreement or a co-decision-making arrangement in place. And that's just simply to help them personally transition to an arrangement of managing their own accounts and funds. Under the current system, where somebody doesn't have any natural supports, then they must seek a panel member from the DSS for this purpose. And Anya has already mentioned that they must work accordingly as a co-decision maker would. But ideally, we would believe that in any future review of the Act, consideration should be given to the formation of distinct panels for the purposes of a co-decision making arrangement. Our next point is that we believe that independent advocacy needs investment. We have unfortunately got waiting lists in some counties. At the end of January, our waiting list stood at 222. The Assisted Decision Making Act commencement has seen a major increase in our workload with no additional resources. And we do believe that a very key thing that needs to be looked at is a government strategy on independent advocacy to consider such increases and future resourcing. Currently, in terms of training provided by the Decision Support Service, that is available to panel decision-making representatives, as we understand it, not to family and informal supports who become DMRs. And this can mean at times that the guiding principles of the Act Code of Practice can be poorly understood and applied. Keeping, I suppose, on that note, we would believe also that it is important to increase information and support to clarify the distinct difference between the role of a wardship committee versus the role of a decision supporter. This is particularly important where former committees may be taking on the role of formal decision supports. And finally then, differing systems for capacity assessment. The current system has a two-tier system for capacity assessments, one medical for wards of court and one functional multidisciplinary for others. So those assessing capacity in ward of court discharge cases include court-appointed medical visitors who are currently registered medical practitioners. However, for the other applications, Part 4, 5 and 7 under the Act, functional capacity assessments can be conducted by a far wider prescribed classes of assessors, including nurses, midwives, occupational therapists, speech and language therapists, and social workers. And we would feel that the inclusion of multidisciplinary roles is key to a move away from a purely medicalised approach to a UNCRPD compliant one in keeping with social model of disability and indeed a human rights-based approach. We do believe that comprehensive information on the person is important. It's been our experience in some of our work that when people have come to meet the person to assess their capacity, at times they have been given limited information on the person in advance of these meetings. And at times they've only met with the person once. They may not have been given vital information on the person's preferred communication style, their need for a translator, information on their day-to-day life, support plans, or indications of decision that the person routinely makes themselves. We do believe also that access to legal representation for the person remains key and critical, and advocates have played a really important role in supporting as many people as possible to access their own legal aid. It has been common to see, in our experience, committees accessing their own legal representation, but not always supporting the person to do so. And it is essential that each person has access to their own solicitor without any undue influence by third parties to uphold fully their autonomy and rights, and that they equally have sufficient time with their solicitors. Early referrals to advocacy are important, where the person does want an advocate, and this is to allow sufficient time for meaningful engagement When we get last minute referrals with court dates approaching, we cannot engage in a meaningful process to ensure that we are truly representing the person's voice. Finally, I would just say that it is important to continually strengthen the participation of people with disabilities in the ongoing design, delivery and evaluation of the Act and its associated systems. Anybody interacting with a person can support them to make an inquiry to the National Advocacy Service, and our details are there. Our phone line is open Monday to Friday, 10 to 4. You can make inquiries through our website by downloading an inquiry form, indeed by post, in person, or by contacting us at info@advocacy.ie. Thank you very much.
Thank you, Joanne. Thanks for a really comprehensive presentation again. And as I said, Joanne's presentation will be available after today's webinar. We're going to quickly move now to a video with PJ Herlihy and Michelle Angland from Kerry. And PJ is going to talk about his experience of exiting Wardship. And then after the video, we'll have time possibly for one or two questions. We're kind of tight on time today, but any questions that we aren't able to answer, we're going to develop an FAQ with our panelists so that there's a follow-up afterwards. So Tom, over to you in terms of the video. Thank you.
Hi, my name is Michelle England. I'm Assistive Decision-Making Coordinator in St John of God Curry Service. I'm delighted to introduce PJ Herlihy, who is a ward of court, and PJ has very kindly agreed to tell us his story and how he has found the process of being discharged from ward of court. PJ's committee is a solicitor based in Dublin.
My name is PJ Herlihy. I sit in tree. I was born in not in gas. I got I always try. I got no brothers. I said the dog with people. I moved back to training 2003. I got my own department. I work in Gab. I like it. So I like it. With a lot of people.
PJ, can you tell us how you became a ward of court?
I was knocked out 1997. The car crash. I go to court. I got money in court. I got money out to crack the court. That moved back to the. I was knocked out. I got money and to got to court and then I got money out the house, the farm in that gas. 1997, and that moved to Dublin too. I'm in Dublin. What? Money the sack for the solicitor, for the sack, and the what? The solicitor sit down the money to me. I could form myself one sack to four, and then I could get my money for kills, prepare go the hotel kill on by something that from my girlfriend all the kill something like that.
So PJ, we're trying to support you to understand what it means to be discharged from wardship. So we have some easy read material developed for PJ to understand what steps are involved in the process. Information is given to PJ in a way he understands and in line with his assessed communication. He is met at a time and place that suits him, and this aids us support PJ to build his capacity and understanding.
I sat in a shop for court, and Matt called to see me. He taught me about my money, my air, my EPUB, for the next step.
PJ will explain a second visit from a medical visitor who carried out a functional capacity assessment.
And Matt called to me. He do set with me. He talked to me. He made something for Sir John got. But my money. What goes fast to the fruit.
Following assessment, PJ will require the assistance of a suitable person as a co-decision maker in managing issues relating to his health, his welfare and financial matters. PJ, what are your hopes after being discharged from Wardship?
Oh, I got no more to do with it. Get someone get my money, I need to get my money. No more double. Maybe someone, they knew what, get to my money, they knew what F me, to my money. I ought to go to cook myself. I don't know what to say. I ought to be there myself. I said, that man was too late to me. I drive with it's very good. I want to fight, but the last fight went for me. I went to W4 the 28th of January 2025. I got this made well, but like I say a lot, as it's soliciting Canada, beginning, if you make active, I like what we had. I got my way, we say I want what voted, and then we start make for me. It allowed me to talk everything so solid. I made sure, I think we're sure. I made a lot before we sat with Sir John God. What a big sailor. I made what more to me. I made full access to my own money. They I knew where my money in the bank. I inside I paid my money on. Till my bill, I paid my money. I could make my own cycle. I paid more cotton, more independent, and more like myself. And this made it well. It lived in a poor and more freedom. Big cut and no, and not a law. I don't know what I get myself. I want someone who's son separate. I want to help me. I proud of that I come. I greet everyone who helped me to get there.
PJ is now discharged from Wardship. He has support that is tailored to what he actually needs. The focus is on helping him be as independent as possible, but still have someone to help him with the decisions he cannot manage alone.
So just to acknowledge that PJ and Michelle are online and have watched this. So just to say thank you so much, PJ, for sharing your story with us and for sharing the update, because PJ actually shared his story with us at a conference that we had in 2024 when PJ was just going through the process. And it's so nice to see that you're out the other end of it and that you're getting all the support that you wanted. So really appreciate your time and taking the efforts and with the support of Michelle in making that video for us today. If I could just ask our panelists to put on your cameras just for the last couple of minutes that we have remaining. We only have 3 minutes remaining, but I know our panelists have been flat out responding to I think it's over 50 questions now at this stage. What I might do is just in the remaining moments that we've left, I might just ask each of our panelists if there was one thing that you could recommend to people that are listening today, what they could do to support somebody, or if there's families here that are kind of worried about this or just need some support in terms of helping the person that they're committee for, what one thing might that be? And I might start with Joanne, just as, just like what kind of one thing would you recommend people could do? Thanks.
It's probably a very simple thing, really, Quiva. It's providing people with information that's relevant and accessible. There's really good resources available, but what some of our advocates are finding is that they're not being put in people's hands, or their supporters' hands. So it really is important to keep people at the centre of what's happening. That first and foremost, they have a grasp of what these changes mean for them and what their options are, what their rights are, and that they know their voice is really integral to the whole process, and that if they need advocacy, if they don't have opportunity to have their voice heard or represented, that they're supported to make contact with ourselves, and that we can support them to ensure that that happens for them. Thanks.
Great. Thank you, Joanne. I might move on to Anya. Anya, if you could answer the same question. So what one thing would you suggest?
This is quite specific. It's just the forefront of my mind because we've been involved in delivering training lately on co-decision making as an outcome of the discharge process. We've been presenting to the Legal Aid Board and yesterday to the courts service on that. So I would encourage anyone coming out of Wardship and thinking about that mid-tier support, because it's a good outcome always to end up with just the highest level of support which you're going to need. And if that's a co-decision making agreement, consider early who you want to be your co-decision maker and what you want to have in your co-decision making agreement, because that will help with the creation and the registration of that document. So it certainly is beneficial to turn your mind to that as early as possible in the process. Lots of other information that you might want to equip yourself with is to do with Part 6, and we have resources on the DSS website. But on that point, I would encourage early attention to what would go into your CDMA.
Great, thank you, Anya. Eleanor?
Yeah, I suppose just important to signpost people, I suppose, from our perspective, to the legal representatives as early as possible. I know that the wards are being represented, I suppose, at this stage, but engage yourself as a service provider or as a professional with the process. Encourage the families to engage with the process so that a whole picture is available to the court about the case and about the person involved, so that the right orders can be made at the end of the day. There are resources on our website for families, for relevant persons, and for professionals assisting people with these cases. So I would encourage people to look at that as well.
Great, thank you, Eleanor. And finally, Alice.
Thanks, Quiva. I would just ask for any service providers who want to submit a functional capacity assessment on a ward who is a client of theirs, that they can do so. They can make contact with the office about submitting that report, and also to ensure that there's support for the person when they are being served by the solicitor with the documents for the discharge application.
Great, thank you very much. That's really super. Just I have a couple of things just to finish up on. First of all, I want to thank our panel. As you can see, there's a lot of work in condensing very complex information into a short presentation, but also our panel have been flat out, as I said, answering questions on the hoof, which is not an easy task. So just bula bus, and thanks very much for that. Again, I want to thank thank our own team, and I want to welcome back into our webinar series Orla Brannigan, who's back with us again answering questions, which is fantastic. We will share the link of the recording afterwards, and then for those that completed the survey, we'll be sending you out the information for your CPD. For those that aren't on our mailing list, please contact adm@hse.ie so we can add you on, or just send us an email directly to any of us. And the next webinar is going to be in March. We don't have a date yet. It'll be on enduring powers of attorney. You'll see some faces here. Anya will be back to join us, I hope, for that one. And again, there will be other webinars. We're going to have one once a month, which is really kind of a lot of them are interrelated as well. And if you have any questions, again, please, by all means, send them in to us. So without further ado, thanks everybody for your participation today and for your questions. And finally, once again, thank you to our panelists. Have a great week. Thanks so much.